Hello, welcome back to another in the 10-minute tip series of recorded programs for credit and collection professionals. This one is titled, What Credit Professionals Need to Know About U.S. Bankruptcy Law. My name is Michael Dennis. Let's go ahead and jump in. Introduction to Bankruptcy Laws. In the United States, bankruptcy is intended to help companies and individuals to eliminate burdensome debts, not to simply repay the debts, but to eliminate them. In the US, the majority of bankruptcy filings are consumer bankruptcies. However, in this entire presentation, we're not going to focus on consumer bankruptcies at all. We're going to focus only on business bankruptcies. In a business bankruptcy, the bankruptcy court and the rules governing the actions of the bankruptcy court dictate that debts will be broadly classified as being unsecured, secured, or priority claims in bankruptcy. It turns out that most business-to-business trade creditors, because they sell on open account terms, will have an unsecured claim in the bankruptcy. In other words, a relatively low priority claim in the bankruptcy case. And because our claims in bankruptcy, generally speaking, have a low priority, that is what results in unsecured creditors in a bankruptcy when it is resolved, receiving normally pennies on the dollar, typically, in my experience, somewhere between 0 and 20 cents on the dollar. If there is a payout, it's usually less than 20 cents on the dollar for us, in my experience as an unsecured trade creditor. Introduction continued. The goal of the U.S. Bankruptcy Code is to give debtors a financial fresh start. It is not to make creditors whole. Bankrupt debtors typically do not repay all of their pre-petition debts. Pre-petition debts are obligations owed up to the day before the date of the bankruptcy filing. In fact, unsecured creditors typically receive pennies on the dollar. In my experience and in my opinion, bankruptcy-related losses are unavoidable for general unsecured trade creditors. Why? Because there are risks associated with every open account sale that we make to any customer, including a customer who's a Fortune 500 company or otherwise looks like a stellar good credit risk. There is always a risk of non-payment, and there is always a possibility of a bankruptcy filing. The parties in a bankruptcy. These are the key parties that you should be aware of in U.S. bankruptcy law. There's the debtor in possession. So in a Chapter 11 bankruptcy, which is the most common type of business bankruptcy, the customer, after filing bankruptcy, is referred to as the debtor in possession. What it refers to obliquely is the idea that the debtor is in possession of the assets of the company and is expected to continue to manage those assets and the operations of the company. In addition to the debtor in possession are the creditors, and that is a broad category. There can be, as an example, unsecured creditors like trade creditors selling on open account terms. There can be secured creditors such as banks, and there can be priority creditors, including, for example, employees of the company that are owed wages prior to the date of the bankruptcy filing. There is, of course, a bankruptcy judge because it is the case is going to be managed and controlled ultimately by the bankruptcy court and the bankruptcy judge. And sometimes a trustee will be appointed. More about the trustee in the entire on-demand program. Why companies file for bankruptcy? Well, there are a broad number of reasons why specific companies fail and ultimately file for bankruptcy protection under the U.S. Bankruptcy Code. I'm going to list a variety of the more common reasons why this happens. Number one, the business, the company, the failing company is undercapitalized or over-reliant on borrowings and or trade credit. In other words, they borrow so much that they become top-heavy and they are unable to make their interest and or principal payments on their debts, and or they are unable to pay their trade creditors on time, and as a consequence, ultimately, they find no other option that is viable for them other than a bankruptcy filing. Another reason why companies end up filing for bankruptcy is that their products or services are no longer in demand. They fail to keep pace with changes in the marketplace in terms of demand for the products that they sell, in terms of product variety, quality, style, price, etc. And as a consequence, they cannot generate enough sales, and as a consequence, they file for bankruptcy protection on that basis. Often the reason or a contributing reason for a business bankruptcy is that the company, the debtor, is mismanaged, it's underperforming, or it's unable to generate a profit. In addition, and unfortunately, business bankruptcies, business failures can result either entirely or in part from fraud or mismanagement, and occasionally from external factors such as a natural disaster. Myth versus reality. There's a long-standing myth that for whatever reason, creditors are required by law to extend open account credit terms to a bankrupt customer, a customer who has filed as an example for a Chapter 11 reorganization and is currently a debtor in possession, the DIP. In reality, we, creditors, are under no legal or moral or ethical obligation to extend credit to a debtor in possession company, period. It's just an untrue statement. It is a myth, it is a misconception, and it has no basis in reality. A decision about whether you, as a creditor company, want to or choose to or decide to extend credit to a customer after that company has filed for bankruptcy protection is entirely up to you. And in addition, if you, as a creditor, decide that you do, in fact, want to offer open account terms to a bankrupt Chapter 11 company as a debtor in possession, you get to decide what payment terms to offer to the customer. It is irrelevant what your prior payment terms were. They could have been net 30 and you could choose net 10 days. You could choose the new payment terms. In addition, it doesn't matter what the old credit limit was prior to the date of the bankruptcy filing. You get to decide what credit limit to assign to that bankrupt customer. And there's nothing in the bankruptcy code, and there's nothing outside of the bankruptcy code that dictates or requires that we make any positive decision, and if we do, that we, as an example, match the payment terms or the credit limit that we offered prior to the date of the bankruptcy filing. Another pervasive myth is this one. There's no risk in connection with extending open account terms and selling on open account terms to a bankrupt company, a customer in Chapter 11 bankruptcy. The reality is exactly the opposite. There is no guarantee, there is no guarantor. No creditor company selling to a bankrupt customer is guaranteed payment. Why not? Because for a guarantee to be in existence, there would need to be a guarantor, and there is no guarantor in connection with your decision to extend open account credit terms to a customer in bankruptcy. As a result, both the money that the customer owes to you up until the date of the bankruptcy filing, if any, and any amount that you choose to extend to that customer in terms of open account credit terms after the date of the bankruptcy filing, referred to as the pre-petition balance and the post-petition balance, those balances are always going to be at risk because there is no guarantee and there is no guarantor of their payment. Your rights following a bankruptcy. You as a creditor can decide to become a petitioning creditor to force a customer into bankruptcy. Once the bankruptcy is in place, you can place that customer on credit hold and you are entitled to stop orders in transit to the customer. You can file a reclamation demand, you can offer open account terms, you can refuse to offer open account terms, you can refuse to sell on COD, you can refuse to sell on cash in advance terms. You can demand payment against some form of guarantee that you have, such as, for example, a letter of credit, a standby letter of credit, or a credit insurance policy. You can choose to join or refuse to join the creditors committee if you receive an invitation to do so. So thanks for hanging in there. I hope you found this program to be helpful. This is an excerpt from a 1 hour long on-demand program on the same topic. For more information about that program or any of the other programs in the on-demand library, please contact my sponsor, the Wisconsin Credit Association, and thank you. Bye.